You're muted. Thank you.
Yeah.
Honorable participants, before we start, we will first listen to the Indonesian national anthem. Assalamualaikum warahmatullahi wabarakatuh. Shalom. Om Swastiastu. Namo Buddhaya. Salam kebajikan. Majua-jua, which means best wishes in Karo language. Salam wari pagi-pagi, which means good morning. Uga beritandu, which means how are you? The Honorable Rector of Universitas Sumatera Utara, Dr. Murianto Amin, Dean of Faculty of Law, Dr. Mahmud Siregar, and all Vice Deans, lecturers and speakers of our summer course program, lecturers of Faculty of Law from Universitas Sumatera Utara and other universities across Indonesia, students, and all participants. We would like to welcome you all to our international summer course program organized by the Faculty of Law, Universitas Sumatera Utara. In the upcoming 2 weeks, we will bring to you our summer course activity with the main theme, Alternative Dispute Resolution, Rakursi Telu in Karo, complemented by sessions on dispute resolution by international lecturers. Lineup of lecturers include Professor Ainul Jaria Binti Maidin, Professor Akmal Handi, Professor Kurnia Warman, Mr. Matthew Zurstrassen, Professor Runtung Sitepu, Professor Rosidar Semiring, and Dr. Maria Kaban. I would like to move on to our first agenda by giving the opportunity to the Dean of the Faculty of Law, Universitas Sumatera Utara, to give an opening remarks. To Dr. Mahmud Siregar, the floor is yours, sir.
Assalamualaikum warahmatullahi wabarakatuh. Good morning. The Honorable Rector of Universitas Sumatera Utara, Dr. Murianto Amin, Professor Prof, Vice Rector for Research, Community Service and Collaboration, Professor Himsar, Director of Internationalization and the Global Partnership, Vice Deans, Faculty of Law, Universitas Sumatera Utara, lecturer and speaker of our summer course program, Professor Ainul Jaria Binti Maidin, Professor Akmal Handi, Professor Kurnia Warman, Mr. Matthew Joranström, Professor Runtung Sitepu, Professor Rosnidar Sembiring, and Dr. Maria Kaban. Lecturer of Faculty of Law from Universitas Sumatera Utara and other universities across Indonesia, students, and all participants. Alhamdulillah Rabbil Alamin that we are blessed to be able to organize our online summer course program, Alternative Dispute Resolution, Rakursi Telu in Karo. For Universitas Sumatera Utara, Faculty of Law, the summer course is a strategic opportunity to bring together lecturer and student in USU and international network for academic collaboration. To date, there are more than 163 registered participants for our summer course program, 33 of which are foreign students from Malaysia, Malagasy, India, England, and the Philippines. The remaining are students from more than 43 universities around Indonesia. We also note that there are lecturers who also participate. We are very pleased to have you with us. Honorable lecturers and all participants. Adats and customs play an important role in Indonesian society. Adat law or customary law is a compulsory course in law schools in Indonesia. The understanding of kinship provides deep insight into human relationship and alliances. This also includes the way social and economic resources are dispersed in society as well as how conflict or disputes within the society is resolved. We hope that this activity can provide you insight and learning opportunity about Rakut Sitelu as one of North Sumatra's local wisdom, complement by seasons on dispute or conflict resolution by international lecturers and speakers. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Mahmud Siregar. Next is a remark and official opening of the summer course program by Director of Universitas Sumatera Utara. Please welcome Dr. Murianto Amin.
Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Good morning, selamat pagi, salam sehat, salam sejahtera bagi kita semua. Om Swastiastu, Namo Buddhaya, salam kebajikan, Najwa. Good morning, the Honorable Dean of Faculty of Law, Universitas Sumatera Utara, Dr. Mahmud Siregar, and Vice Dean, Faculty of Law, Director, International Association, Universitas Sumatera Utara, lecturers and speakers of our summer course program. I think this is it can be asked Professor Aino Jaria binti Maidin, Professor Akmal Handi, Professor Kurnia Warman, Mr. Matthew Distractions, Professor Untung Stepu, Professor Rosidar Sembiring, and Dr. Maria Kaban, lecturers of Faculty of Law from Universitas Sumatera Utara and other universities across Indonesia, students and all participants. Alhamdulillahirabbil alamin, we are thankful for the blessing of Allah Subhanahu wa Ta'ala, the God Almighty, which allow us to gather online today for the opening of the Faculty of Law Universitas Sumatera Utara International Summer Course Program, which title and Alternative Dispute Resolutions Rakut Sitelu in Karo. Honorable lecturers and all participants, the summer course activity is the first activity in 2022 organized by USUS Faculty of Law. One of the most important themes in the summer course held at Universitas Sumatera Utara is the theme we are currently participating in, which is about local wisdom. As we know, Indonesia is a unitary state based on law. As a state of law, the Constitution gives respect and acknowledgement to the availability of customary norms in people's lives. Customary norms, lives, and regulate the order of people's lives in various regions within the framework of national law. Customary norms are also applied to resolve conflicts or disputes outside the courts. The province of North Sumatra or Sumatera Utara is ethnically diverse. It has a myriad of local knowledge and wisdom. And one of the local wisdom in Sumatera Utara is Rakut Sitelu is a kinship system of the Karo people in Sumatera Utara, among other systems in Indonesia. Honorable participants, this summer course activity aims to showcase the application of customary norms which focus on Rakut Sitelu in solving problems related to disputes and conflicts outside the court. This activity can be an opportunity for participants to do comparative studies and broaden their horizons about dispute resolutions. For Universitas Sumatera Utara, this is an opportunity to us to expose the local wisdom in Sumatera Utara and promote customary law so that it can be better known by the world's community. In line with that, we hope that this activity can also enhance the university's international academic reputations. So we hope many participants in this summer course can know what the activity in Universitas Sumatera Utara. In addition to the lectures and discussions that have been designed in this program, we also believe that this event will be able to bring together lecturers and students in Universitas Sumatera Utara and international networks for further academic collaborations, such as joint research, study visits, student exchange and lecture exchange, or postdoc, or other activities can we bring commitment together. In the name of Allah Subhanahu wa Ta'ala, the God Almighty, Bismillahirrahmanirrahim, I hereby open the International Summer Course Program of the Faculty of Law Universitas Sumatera Utara. I officially welcome you all to Universitas Sumatera Utara, and may we have a fruitful activity. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sehat, salam sejahtera. Om Santi, Santi, Santi Om, Namo Buddhaya, Maju Ajwa.
Thank you, Dr. Muryanto Amin. Next, we are moving on to the awarding of tokens of appreciation by the Rector of Universitas Sumatera Utara, represented by the Dean of Faculty of Law, to Professor Akmal Handi Nasution on behalf of all lecturers. Honorable participants, that will be the end of our opening procession. We would like again to thank Dr. Muryanto Amin, Director of Universitas Sumatera Utara, and Dr. Mahmud Siregar, the Dean of the Faculty of Law, Universitas Sumatera Utara, for your time to open our summer course program. And we are now moving on to the first session of the program. And before we start, I would like to again remind you that you are encouraged to have your video on during the entire session and your audio muted. And without further ado, I would like to hand over the session to the moderator of our first session, Tunisa. Please, the floor is yours. Thank you very much. I'm Detania Soekardia. Please have a fruitful discussion during our summer course program. Assalamualaikum warahmatullahi wabarakatuh. Good morning.
Okay, thank you, Miss Data, for a wonderful hosting today. Good morning, ladies and gentlemen. Depending on you are, welcome International Summer Course Program organization by Law Faculty with the theme Alternative Dispute Resolution in Karo. First, let me introduce myself. My name is Siti Khairunnissa. I be responsible for hosting, and I'm glad to welcome Prof. Akmal Handi Ansari Nasution, who will present alternative dispute resolution in global perspective. I will welcome you all day today, and thank you for participation. The session should take 30 minutes. Before we get started, I would like to go over a few times so you know how to participate to this event. Before we get started this morning, I have several announcements to help make your day more pleasant and productive. Mute your microphone if you are not speaker and to avoid your sound feedback. You have a question to speaker, please raise hand, then I will unmute you. You only need to select the small icon in the platform raise hand. So without further ado, let's start. Allow me to introduce the first speaker for this event, Professor Akmal Handi Nasution with the qualification education first. He graduated from the Universitas North Sumatera, Bachelor of Law, specializing in business. He graduated in 2011, and then he continued Master of Law at the University of North Sumatra, and continue in Queen Mary University of London, United Kingdom, Master of Law with dissertation, due process implication in the witness examination with two-way video conference in international arbitrations. And he have a education in Den Haag Academy of International Law, Public Private International Law in January 2019. About the professional experience, Jindal Law School. She is assistant professor of legal practice, course instructor for international law, international trade law, and international human rights law, and theory in spring and fall semester respectively. And the course instructor for the trade, environment, developing countries as elective course. Until the present, she is the visiting lecturer of international at a university and the Pendidikan Khusus Profesi Advokat legal practice. She is been experienced in Bank Mandiri Europe Ltd, London, United Kingdom, November 2018 till January 2019. After 2 days, training provide temporarily replace the treasurer, was responsible for foreign currency trading with the client counterpart in Indonesia, and successfully made a single deal worth 2,115 pounds in the forex trading and smoothly maintain the bank's business in the money market. Maybe that's all the curriculum vitae, many experience that I cannot mention one by one. So we continue for the presentations. So before we start, as we know, each country usually creates dispute. In the 21st century, many disputes nowadays are being solved through IDR, Alternative Dispute Resolution. So IDR begins to make its own mark in every country so that it will deliver. Our speaker, with Professor Akmal Handi with the topic International Dispute Resolutions with the Global Aspect. I would like to welcome the speaker to deliver the presentation. All right, Mr. Akmal Handi Ansari Nasution, time is yours.
Thank you very much, Nisha, and thank you very much for this kind opportunity. I'm sorry for the feedbacks. So please give me 1 minute to settle my screen, because in my institution we are only using the Microsoft Teams. I hope you can see my screen. If anyone can respond, that would be great. Can you see my screen, ladies and gents?
Yes, we can see you.
Brilliant, thank you. So yeah, thank you very much for this kind opportunity for the North Sumatra University, and also of course it is the place where I learned law in the first place, the first time in my life, and then I did my, as Nisa already kindly elaborate my CV before all of you. I did my bachelor, my first master's. I learned about the methodology on legal research from our dean here, Dr. Mahmoud Siregar, and also about alternative dispute resolution from Professor Dr. Runtung. That being said, it is also, I need to, how do I say it? Explain about the disclaimer about my designation. Especially I could see several students from my current jurisdiction, which is India. So as you can see, I have the professor before my name. Meanwhile, the deans, even directors, don't have the professors. After I elaborated about my experience while studying my first master's and my bachelor in this university, and also the names from the rectors and also the other speakers in this summer course are my professors. The professors before my name is merely a designation by my current institutions at Jindal Global Law School. I hope it clear your kind of cloudy understanding regarding the destination or perhaps salutation. Welcome everyone. I could see several. It's pretty international. We have several attendees from other jurisdictions, and namaste for our attendees from India. Well, it's 7:50 in India, I believe. So with this effort, I would like to say thank you. It is pretty early at your end, and yes, good morning. So what is the ADR? I think all of us already understand about the nature of the ADR. It's an out-of-court mechanism to settle the dispute. All around the world, we already know about the conciliation. As the dean already mentioned about the importance on understanding the local wisdom, also echoed by our rector, about local wisdom, all folks highs in Dutch. And also that's in international level, that is also part of the making of international law. In the ICJ statute on the regarding customer international law, of course, there will be there's implications of the lawmaking international law if we have the persistent objector, if the silence can be seen as a consent to the making of this customer international law. However, in this lecture, as the opening lecture in the ADR in global perspective, I would like to bring you, all of you, to where you came from, to look at the societal values, your local wisdom, and then I will bring you to the other jurisdictions, to compare whether we have similarities or perhaps similar approach in resolving the dispute or disputes between villagers or inter-villages or even inter-regions, and also how was the international law or international dispute historically being resolved. That is why I started with this ADR in global perspective. Where were we as humanity, and where are we currently? What was the development in this ADR, in this current ADR system, and where are we heading to? During my studies since 2006 until now, and I can proudly say until now, I am still a law student. Both domestic law and international law has this nature of dynamic. The dynamic, it can be seen, especially with this globalization that we will also discuss later on. How dynamic it is, the complexity of the disputes, and how how dynamic the law is, but also brings impacts or influence, if you prefer, in the dispute resolution mechanism. Back then, during the ancient eras, we already know a knowledge about how to settle the villagers' dispute. Now we are settling currently. We have a lot of disputes when the parties are coming from two different nationals. When the performance of the contract is located in a third country. And we also have this institution that registers the current dispute. And imagine the arbitrators or even the mediators or whoever sitting to resolve their dispute come from different nationals. So that's where are we? All right, let's bring back to domestic law, and then we will continue our journey on the development. Very well. We would like to start, we're going to start with the history of ADR from various jurisdictions. With this current understanding of ADR, that it is out of court dispute resolution mechanism, we have to understand if before the boomed or the trend of colonization. This the ancient ADR it wasn't ADR. It wasn't the alternative. It was the only mechanism to resolve your dispute amicably, peacefully. For example, I'll start from the African from the African continent. In African traditional society, Yoruba and Igbo from Nigeria, and Pondo tribe in South Africa. As this typical dispute resolution mechanism, ancient dispute resolution mechanisms, it promotes consensus building, social bridge reconstruction, and enactment of order in society. Pretty much like it's typical also the feature of the in this dispute resolution mechanism in African traditional society. Those disputes were mediated by the elders of society. The elders were seen as the powerhouse of wisdom and knowledge, either by their own informal or formal even education, or by their own life experience. In certain circumstances, even the gods and the ancestor or the eternal forebears are called upon, their spirit invoked, and everyone, especially disputants, are reminded of the aftermath of their wrath if they refuse to say the truth. It's pretty similar with the this current practice of perjury that we have in our modern court or contemporary court, if you like. And then we move on to another jurisdiction that pretty well known with their alternative dispute solutions. They're known with this Confucian approach. They're known with their mediations. And they also are very well known with their reluctance to litigate, which is Japan. There is one book from our professor, Sachipto Raharjo, about when they're comparing between two airplane crashes that was happened in Japan, and the other one is in the US. The Professor Sachipto explained about the legal culture, the difference of legal culture. When the phenomenon of this airplane crash in the US, within days, the ambulance chaser lawyers already crowding over the victims of the airplane crash. Meanwhile, in Japan, the insurance, as well as the airlines companies, or the airlines company already approached privately privately approached the victims or the family victims of those airplane crash. So it is also to show the difference. Not that I am favoring one legal culture over another. I'm a dispute resolution lawyer by practice myself. I pretty much favor to the adversarial process in the Anglo-Saxon system. I even went to London to study about international arbitrations. This is merely how to show the difference of legal culture between among jurisdictions. In Japan, we have the one of the ADR system. We have the tote as the conciliation. Dispute is settled through negotiation between all parties with the aid of a number of impartial facilitators or conciliators who help the parties to discuss the conflict and devise their own solutions. It is the party-driven dispute resolution mechanism. In comparison with the arbitration that we will discuss later on how the arbitrators can impose the law of the sea, the arbitration rules, even the soft laws. The conciliators will look more to standards such as reason, common sense, equity, and morality. I think it's pretty identical with all of the conciliation methodologies all around jurisdictions, in all jurisdictions, more or less, because it has to be, the conciliators have to be flexible or versatile, if you prefer. Meanwhile, the wakai or compromise is voluntary agreement between the disputing parties and mostly persuaded by the presiding judge. So this particular method is when a dispute already entered the court and then the judge itself recommend them or persuade them to compromise. However, again, it is the rights of the disputing parties, because it's the voluntary nature of the compromise. And obviously, we have the two sides or the arbitrations. The arbitration in Japan, it is pretty similar with the arbitration nature of features, if you prefer, with the European countries or even the US and the UK. That being said, with this wakai and tote, it is mostly they are mostly holding the confusion values of social hierarchy, reciprocal duties, and harmony underpinning the Japanese system are embedded in the tote and wakai proceedings. And then we're moving on to my current jurisdiction, which is India, that I can proudly call as one of my homes. Until now, we have the panchayat. However, this current panchayat, as we can see from Indian constitutions, its duty and functions have been shifted. In the ancient India, obviously, before the Britishers came, one of the panchayat's duty is the settlement of communal disputes, until the current legal system has been installed by the Britishers in India. So the panchayat was there since the Vedic age, and it has been the effective agency of social control. It was gradually made ineffective with the introduction of a more formalistic, legalistic, and impersonal system of justice. And as I already mentioned, the current function of panchayat as unit for rural uplift to free rural India from poverty, ignorance, disease, and misgovernment. Excuse me. And then the other Indian ancient Indian courts such as Kula or Sreni or for the trade or professional councils, Ghana as a field assembly, and the Adikrita, Sasita, and Bripa is pretty typical with the monarch system, as we already understand. Some of the people of nations bring their disputes before their kings, and the kings, with their wisdoms, are expected to resolve the quarreling, the warring parties, the warring parties or the quarreling citizens of his nation. And then we move to the Islamic law. I guess I feel implored to mention that from the Islamic law, it is pretty well codified and detailed and managed in a rather greater detail, taking into account the Quran and Hadith themselves has been published of the Muslims since 1400 years ago. It is how Islam as a society, how to manage to look at to manage the social control, and that is why ADR in Islamic law as basic tenet of civil justice. It is also rather answering this current critique on the legitimacy. We have in Indonesia itself, we have the phenomenon of the legitimacy crisis of the ADR. That is why, and therefore we had the huge numbers of the arbitration awards annulment, or even set aside of the award, or the invocations of the award in the court in the court where the award was made. The Quran and Hadith given unique legitimacy and divine approval. About the legitimate crisis in arbitration all around the world is also part of the complexity of the dispute, especially when we started with this. Oh, imagine you have to. There's a contractual dispute, perhaps the default of payment by a default payment by one of the parties, moving on into the construction arbitration, and then we currently have the Bitcoin or even cryptocurrency dispute resolution. We have that quite trendy, if I may, that has been echoing all around the world. Even several of my friends or colleagues are doing their PhD research on the cryptocurrency dispute resolutions. Back to the Islamic law, the processes, and one of the first one is the sulh, or in English we can look at it from the negotiations or mediations or conciliations or compromise of action. Obviously, as the nature of the Quran and Hadith, Hadith is on how the Prophet and the Prophet, peace be upon him, and how he conduct, or how they conduct his life, and how he managed the society at a time. or it will be more practicable. Meanwhile, the Quran can be seen as the ground norm on how those values can derive from the Quran. So I'm quoting this Surah Al-Hujurat in ayat 10 ayat. The believers are but a single brotherhood, so make peace and reconciliations between two contending brothers, and fear Allah that ye may receive mercy. So it is how the Muslims have the obligations to make peace for the contending parties. Otherwise, they should fear their God's wrath. And the previous ayat 9 in Al-Hujurat, and if two groups of Muslims fight against each other, reconcile them. And if one of them oppresses the other, fight against the oppressor till it returns to the command of Allah. Then if it returns, reconcile between them with justice and be fair. Indeed, Allah loves the equitable. So it is also give the legitimacy to against the oppressor and make peace and or reconstruct the relationship between the two, or even more, or the disputing parties. And then we also, and in Islamic law, it also has its own arbitrations. The Quranic verse in marital dispute, in arbitrating the marital dispute, and if you fear a dispute between husband and wife, send an arbitrator from the man's family and an arbitrator from the woman's family. If these two wish conciliation, Allah will unite them. Indeed, Allah is all-knowing, well aware. So that is how the party appointed arbitrators were formalized in Islamic law. And also the obligations to abide by the word. Or one can see from the contemporary arbitration feature, which is the finality of the award. So all the from the An-Nisa ayat 65. So all the Prophet Muhammad, peace be upon him, by oath of your Lord, they will not be Muslims until they appoint you a judge for the disputes between them, and then whatever you have decided, they should not find oppositions to it within their hearts, and they must accept it wholeheartedly. That is the finality of the award in the Quran. And the due, of course, people will ask about the due process. What about the perhaps the moral turpitude or the behavior of the arbitrators themselves in how they're resolving the disputes? Again, in the same surah, ayat 58, indeed Allah commands you to hand over whatever you hold in trust to the owners, and whenever you judge between people, judge with fairness. Undoubtedly, Allah gives you an excellent advice. Indeed, Allah is all hearing, all seeing. So if we start from the first sentence, indeed Allah commands you to hand over whatever you hold in trust. In arbitration itself, we have the competence. We have the party autonomies on how the parties give their trust, their power to the arbitrators. And this first sentence, it is the reflections of how an arbitrator should being responsible in holding those trusts by the disputing parties. And furthermore, they have to judge with fairness, without, of course, there is a sense of due process or impartiality. It's also and also here listening to Audi et altram parte, listening to both sides. So, and also besides the mediations or reconciliations and negotiations, and also the arbitration that we have discussed, that's also mentioned in Arabic as tahkim. There are other methods such as the Islamic merit arts, the combination of the two, and also the ombudsman, and also in informal justice by the Wali al-Mazalim or chancellor, and the expert determination or fatwa of muftis. And then moving on to look at, since before we move into the current model of arbitration, in Indonesia itself, we as one of the main topic of the summer course itself is about the Rakut Situlu. The Honorable Professor Runtung Stepu will discuss in a greater detail about one of the ancient model. One of the ancient models of the dispute resolution in Indonesia. And as pretty much with the other jurisdictions, as if I may, the third world countries, after the colonizations of the Dutch, we already have the settled legal system, and we have the formal courts, all in almost of the major islands in Indonesia. And then, however, our Indonesian values in settling the dispute amicably has been there, and that is why in civil disputes there is a mandatory the presiding judge have to command the disputing parties to go over the mediators either they are chosen by the disputing parties or the court appointed mediators. We also have our own alternative dispute resolution and arbitrations from 1999, but still, as I said, the nature of the law is dynamic. During my experience in practicing as dispute resolution lawyer in Indonesia, we hardly made efforts in the court-appointed mediations. We really wanted to litigate. That is the regressing value in our litigation culture. Then perhaps it is because of the development of the informational technology as well as the globalizations. Now moving on to the current model of arbitrations, or this current familiar model of arbitration, the Athenian arbitration, and its development. It can be dated from the end of the 5th century BC from Greece literatures. Even it is older than Islamic literatures. As I mentioned, the Quran was there since 1400 years ago, but the Greece literatures can be found from the 5th century before Christ. So it means like it was 2,500 years ago. Since the very beginning, it has recognized the party autonomy. And also, in case of a rejection of the arbitral award, the dispute was taken to the regular law courts. Even until now, the English Arbitration Act, if there is a serious irregularities in proceedings, the disputing parties can file an appeal before the English court if the arbitration was made, the arbitration award was made under English law. So so this current model of arbitration was transplanted from the Athenian arbitration, and obviously it gains popularity in the European community. Okay, the earliest arbitration law in England was in 1698, at the end of the 17th century. And that is one of the biggest, as we already know, the UK itself is the, as we already know, how it spread all over the world. Since if we recall, from how Winston Churchill was proudly say, the sun never sets in British Empire, to show how wide and vast the British Empire was, and perhaps is. And also this in France, in one of the biggest colonizing countries, it was the Code of Civil Procedures in France already codified the arbitration since 1806. And internationally, and also look at the other big jurisdictions such as Russia. I will remind you the establishment of the PCA in the Peace Palace that was built by Andrew Carnegie in The Hague was initiated by the Tsar of Russia, Nicholas II. A few years of, ironically, the establishment of the PCA in the Peace Palace, it was several years, a few years before the First World War, or we currently say as European War. So yes, in the this Athenian arbitrations, even back then, when they have arbitrations for private matters, perhaps commercial and public arbitrations, even arbitrating dispute between polis, as or we call it city these days, and even internationally at that time. So, and the development of international arbitration can be seen from the establishment of the PCA in The Hague, in the Peace Palace in 1899, and further in The Hague, in the same revised or amended convention in 1907. Article 16 of the convention, in questions of a legal nature, and especially in the interpretation or applications of international conventions, arbitrations is the most effective and at the same time the most equitable means of settling disputes which diplomacy has failed to settle. If we look at the very first sentence, in questions of a legal nature, in the current arbitrations, one can argue that current is heavily regulated, that we will discuss later on. That being said, it brings back to us this question from the let's say, the theory from Roscoe, are we going to achieve justice without law? Like we used to have in mediation, negotiations, conciliation. Do we really have to go to these adversarial systems? Please hold that question in mind. And the Article 20 of the same convention, with the object of facilitating an immediate recourse to arbitration for international differences, which it has not been possible to settle by diplomacy, the signatory powers undertake to organize a permanent court of arbitration, accessible at all times and operating unless otherwise stipulated by the parties, in accordance with the rules of procedures inserted in the present convention. It's about a question on access to justice. But if we bring back Roscoe writing into this, access to justice, does it really always have to involve law? Perhaps this mind-opening question can be always dangling in your minds during this summer course. As the dean already eloquently, and as well as the rector already eloquently explained about the importance of understanding the local wisdom. Back to our discussion on the PCA, it is acting as registry in investor state, one of the most investor state disputes that has been registered registered in PCA was UCOS arbitration as the highest amount of arbitration, even though the award is set aside in the Dutch court, but it hit the record really, and contract-based arbitrations. Besides arbitration proceedings, PCA also providing service in conciliation and mediation. And commercially speaking, in 1999, the world's business community established the ICC, the International Chamber of Commerce. In 1923, the ICC created its Court of International Arbitration to provide framework for an independent and neutral arbitration system for the determination of commercial disputes between parties from different countries. And then that also, and this again, the dynamic and the development of the arbitration, there was a question about the enforcement of the award. And then we had the 1923 Geneva Protocol and 1927 Geneva Conventions about the enforcement of the International Arbitration Award. And currently, and it has been proudly boasted by the international arbitration communities, and also one of the most successful convention that has been signed more than 150 member states, which is the New York Convention 1958. And how the arbitration award that was made in London can be enforced and then the winning parties can pursue the losing parties in assets in numerous jurisdictions, as long as the court where they're enforcing the awards is a member of the New York Conventions. Pretty practical in a way, and also bring predictability in the international commercial community. And then the regarding, well, we all know in the first half of the 20th century, with this independence movement all around the world, in Asia, in Africa, and in Latin America, those countries, those former colonizing countries, or even the current colonizing countries, have this concern to access the resources. Imagine, in this current example, as we speak, Indonesian and Malaysian palm oil production, 70% of those palm oil productions are exported to the EU. So that is also how, why they will just follow the money. Where does the money goes? And who consume the resource the most? And then back to the discussion on Washington Convention in 1965, with this movement of independence all around the world, in Africa, in Asia, and in Latin America. They come to well, one might see that I have this approach as with the 12 approach, but I am unable to say it other way, to access those resources by way of investment, and with, of course, to maintain the due process, to safeguard the rights of the investors. They have the Washington Convention on the Settlement of Dispute, or the Exit Convention, and the Exit itself is using the arbitration methods instead under critique the lawmaking and investment dispute that were made by the small pool of arbitrators with the repetitive appointments, that makes the developing countries or the third world countries, the former colonized countries, unable to settle their own values. That is why we have this summer course in the first place. What are the enforcement of the implementation of the report are quite heavily exploited, if I may. And as we already know about the appellate body crisis that has been there since December 2019, December 2019, the several member states created the multi-party international appellate proceedings, but not all the WTO members are member states of this MPIA agreement. One of them, obviously, the member state that created the fiasco in the first place is the US of A. As the interim agreement itself, as the name suggests, it is an ad hoc body that will dissolve itself after the appellate body has been reestablished. And we have this current, as a lot of scholars already mentioned, about the redevelopment of the ADR. One of them is the mediations, the UNCITRAL model law. We even have the UNCITRAL model law on international commercial mediation and international the first just 2 years ago, less than 2 years ago, and until now, Indonesia is not a member state of the. And the other method of alternative dispute resolution in the ISDS, which is the cooling off periods. It varies from either bilateral investment treaties or multilateral investment treaties. They mostly have this 6 months cooling off period on the which essentially they require the investor to abstain for a specific period, as I mentioned, mostly 6 months, from initiating arbitration proceedings again. The investor have to abstain from initiating any proceedings, especially the in particular the arbitration. And also in the dispute settlement understanding in the WTO dispute settlement bodies, it is before they go essentially tries to resolve a dispute by diplomatic means and has frequently been successful in resolving the dispute. And as I already mentioned, the MPI was known and recognized by nearly all the civilizations. We have one chat. Yes, Bayu Fita, I will come into your questions after I finish this slide. Thank you. Yeah. The idea of ADR that prevent compromise over confrontation was known and recognized by nearly all the civilizations, particularly in Asia and Africa, until the colonizing countries installed their court systems in their own colonized territories. On the other hand, of course, this fast pace of globalizations, it demands the sense of uniformity in resolving the dispute. And the current model of ADR, such as arbitration, mediation, expert determination, conciliation, has been globally recognized. And obviously, the dynamic nature in both public or private international law that demands the development in dispute resolution. And that is why we have this summer course to found values that can contribute in the development of current dispute resolution system, either domestically or globally, as we can see from our development in the ADR system, in our own national laws, for my fellow Indian students, from your stare decisions, and how the arbitrators, perhaps they made the law, or they do they not, or they follow the previous judgment from us, the civil countries from the civil countries background, on how we made the development in our laws. Thank you very much, and I will Bayu, are you a specific part of ADR? Which one? Or is it the arbitration or the mediation or the conciliation? The mediation, yeah. So generally speaking, the advantage of the ADR, in which until now, even both from all of them from the arbitration, mediation, conciliations, the first feature that they really adore in their private arbitration is the confidentiality, because it is not published in the courthouse website. It is only between the disputing parties, and the mediators, and the mediators mostly in several jurisdictions has been taken oath to maintain the confidentiality in the disputes that they are mediating, or it's also take places in the taking place in arbitration. However, speaking about arbitration, with the growing numbers of soft laws from IBA rules, IBA guidelines, one critique that has been addressed since the early 2000s was the offer regulations of the arbitration. For the mediation part, it is currently, if they agree to resolve the dispute, mind you, it is the mediation is more voluntary, more amicable. So I would like to ask if a country of a part of the dispute, if it's a member, not a member state of the New York Convention. Not yet. Wait. Oh, Bayu, does that clear your doubts, or do you need any further clarifications? Bayu? Meanwhile, I will answer. For example, let's say there is a country like, let's name the country Mauritania. I am a nation. I'm a business person or businessman. Oh, great, thank you, Bayu. So well done. So about the let's say I am a Mauritania citizen or nationals, if you national, if you prefer. I'm concluding a contract with an English national, and then I am default in this contract, and the complainant in this dispute, or the claimant in this dispute, the British national, the British national, bring a claim before me in the international arbitration, one of those international arbitration institutions, and then I was found, and I was found default for like $5 million US. Yes, the challenge will be this British national, let's say Mr. A, won't be able to enforce this award in Mauritania, to seize, for example, my assets in Mauritania. However, Mr. A should can bring this, for example, this award, this arbitral award in other countries that is that have my assets registered in that country, and then this particular country, let's say the US, perhaps I have an apartment in the US, and this Mr. A can enforce the award in the US and seize my asset there. However, in this current this contemporary practice, the Mr. A's lawyer from the UK should have let's say during the due diligence processes should have advised Mr. A not to conclude a contract with me because I am a Ruritania citizen or a Ruritania national. And Ruritania is until now is not a member of the New York Convention, or not a signatory party of a New York Convention. That is the preventive method to prevent his or her client to fall into this kind of situation. I hope it does this area really belong to, that we students and practitioners are not deceived by the implementation of ADR, and how effective is the implementation? Thank you, and please explain. So the ADR in the police and also we have this civil servant. So in Indonesian we have this in the environment and perhaps in the competitions, they have their own, for example, ADR methodological that is embedded in the regulation. So the main purpose of the ADR itself to settle the dispute outside the court. During the police investigations, even though it is not the ADR in the criminal proceedings, it is hardly regulated in our criminal procedural code. However, the discretion from the police from the national police has been taking place in the Indonesian legal system. As we can see from this, as we can see from the practice in Indonesian domestic legal system that has been heavily employed. That is also one of the suggestions in our draft in our criminal code. Who does this area really belong to, so that we students and practitioners are not deceived by the implementation of the ADR, and how effective is its implementations? As I already mentioned about the current implementations, but it has to be seen from case by case basis. From my own experience, as a litigating lawyer, I will object because the acta compromise or within the disputing parties that also have criminal nature in their dispute. If the aggrieved parties objected on the PPNS or even the police will be reluctant to impose it upon us. upon the aggrieved parties, or perhaps the settlement doesn't really benefit or feel that or meet the extent of the aggrieved parties. So it is, I have to say, it has to be based on the case by case basis, but that is the anyway, do not forget to fill your attendance form. I will wait for like 1 minute if we have any other.
Yes, we have 1 minute for the question answer sections.
Question,
Or
or perhaps
any others who give the answer. Sorry, for the question or the participants fills out our attendance form because we have a list absence. Okay, I just remind to all the participants, fill out our attendance form. If you have no question, we have a next agenda. Okay.
all right. Thank you very much, ladies and gents, for attending my opening lectures on the summer course. I hope it gives the. I hope it really tickles your curiosity in the ADR, either academically or practically. I wish you all the best, and hopefully this summer course will give you a fruitful understanding or approach, a new approach, or even a visionary. And I personally hope it gives you like a visionary approach. Where are we heading to? What should we do? And as I've repeatedly explained about in this summer course, looking at the local wisdom in every jurisdiction might give contributions on the development of the ADR all around the world. Thank you again. Thank you very much for North Sumatra University's, the rectors, the deans, the organizers of this event for this great opportunity. And I will see you in perhaps in another event. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. And I will see you in a few minutes, really. Thank you very much and goodbye.
Okay. Thank you, Mr. Professor Akmal Handi Nasution. Thank you for staying with us throughout the whole day. I hope that you have again a lot of insight for our wonderful speakers today. I will summary all the present by our speaker. The presenter has been mentioned IDR in India, Japan, Islamic perspective, and the main ADR is a settled dispute outside the court. As we lawyer, we are objective and a compromise to implement the ADR objective on the proposal depend on our parties. And The presenter has been explained about the mediations UNCITRAL's methodology on the international commercial mediations and the trade disputes. He explained trade dispute arbitration mechanism. So as we know that IDR is a dynamic and a development and need development. So we found the values and we can contribute in development current dispute resolution system, either domestically or globally. Okay, thank you, Mr. Akmal Handi, for the wonderful presentation. For those who still hasn't confirmed their attendance, please fill out this link in the chat box. Okay, I just remind for all the participants, please fill out this link in the chat box, the attendance list. Before we all say our goodbye, we request to everyone to open their camera so that we can take a group of photo. So to all the participants, open the camera, we can take a group photo. To speaker, can open your camera for the group photo as a memento for our summer course, first our summer course in law faculty. So I just to remind all the participants, open the camera to take a group photo. Okay. Please listen to me for the get ready to all. Maybe just one slide have an open camera. So another, okay, another slide. Some of the participants didn't open the camera. I just remind all the participants open their camera. Thank you for participating. Okay, I will wait 1 minute for all the participants to ready up. Maybe ready for your dress or something. Yeah. Okay. For the presentation slide will be delivered in our WhatsApp group. So you can see our WhatsApp group. You can see the chat box. If we have no chat box, we have in a WhatsApp group to deliver our the speaker slide presentations. Okay. Maybe that's enough. Okay, I will give. Okay, okay, we take a photo for the. Udah ready? Abang yang capture kan? Okay, okay. 1, 2, 3. The slide 1. Okay. Okay. For the slide 2. Smile. 1, 2, 3. Okay. The slide 3. 1, 2, 3. Okay. Thank you for the participating to everyone. So I will give some announcement for you for the next sections, our summer course. So please stay at the Zoom. I'd like to apologize if there are any mistake for me as a moderator during the sections. Just information, if you were late to join our sessions, don't worry because you can rewatch the recording from YouTube. We will share a YouTube link in our WhatsApp group. Thank you again for joining us today. We will see you on Friday, the next sections. Don't forget our next session on Friday, 15 July at 9 till 12 p.m. with the topic Alternative Dispute Resolution in Malaysia with our distinguished speaker, Professor Ainul Zaria Maidin, LLB, LL.M, PhD from the International Islamic University. So there's a little announcement from us. Okay, thank you for all the participants. Thank you so much. Maybe we can see on Friday. Don't forget. Okay, thank you. Bye. Assalamualaikum warahmatullahi wabarakatuh. Stay healthy, stay safe.
Thank you.
Waalaikumsalam.
Okay, you can leave the Zoom meeting. So don't forget to on Friday. Thank you.
Thank you, Miss.